Maybe Yes. Yes.
Sorry, I'm like in Professionals meeting, not in this room. It should be started. If she wants to log in, and I'll make her all of them. I didn't even think to make this copy of all. I'm sorry. Almost. You should be able to us now. It's all good. No. That's fine. Come up and put it on the desk with my head started.
Court come to order. All rise, please.
Good to see you.
Make sure all cell phones are turned off or unless you're not authorized to have your phone turned on. Thank you.
Stay ready?
Yes, sir, Your Honor.
Hands ready?
Yes, sir, Your Honor, we are.
All right. Call your case, Mr. Ward.
Yes, sir, Your Honor. The state calls a state grand jury case, State versus Russell Lucius Lafitte. Mr. Lafitte was indicted in 2022 GS 4701. That was a Hampton County indictment for 1, computer crime, 10,000 or more, 1, criminal conspiracy, and 2, breach of trust, 10,000 or more. He was also indicted in 2022 GS 4702. That was venued in Hampton County as well for 1 count of computer crime, 10K or more, 1 criminal conspiracy, and 1 breach of trust, 10,000 or more. And then finally, he was indicted in 2022 GS 4703. That one was venued in Allendale County for 1 count of computer crime, 10K or more, 1 count of criminal conspiracy, and 1 count of breach of trust, value 10,000 or more. Your Honor, Mr. Lafitte, of course, is present. He's here with his counsel, Mark Moore, Todd Rutherford, and Michael Parente. And it's my understanding pursuant to a plea agreement, which I will hand to the clerk and ask that it be part of the record. He plea guilty here today, and I'm happy to address the particulars of that when Your Honor was ready.
You want me to say this recorded with it?
Yes, sir. I'll take it over, Your Honor, if that's all right.
Is Your Honor okay with us staying at the table, or would you like? Yeah, you can stay there.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor, just to go ahead and detail the plea agreement, it is a fairly complex plea agreement. We've obviously got 21 counts to resolve. Ultimately, under this plea agreement, to summarize the terms, in subsection 2, Mr. Lafitte is going to plead guilty to representative charges for all of the subject matter divisions of conduct that were alleged in these 3 indictments. So the factual basis is complete as to the conduct. But ultimately, he is going to be pleading as indicted to count 4 of indictment 2022 GS 4701, count 5 of that same indictment, count 6 of that same indictment. He's going to plead to counts 10 and 11 of 2022 GS 4702, and he's going to plead to count 1, 15, and 16 of 2022 GS 47003. Your Honor, as part of that, of course, there is, as I mentioned before, going to be a full factual basis. Additionally, there's the issue of restitution, which we will take up at sentencing. The intent of the parties here today is to have a deferred sentencing to dovetail with the concurrent federal proceedings. The parties have agreed to the restitutionary amount of $3,555,884.80. Your Honor, that was ultimately funded by the stocks, the bank stocks that Mr. Lafitte owned that were protected within the state system. and having communicated with counsel for both the firm and the bank, is my understanding that wires went through yesterday for those amounts. Additionally, there's a potential additional amount of about $281,000 that represents additional costs, investigative costs to the bank. And of course, in this plea agreement, the parties, if they cannot agree on that amount, will need to have a restitution hearing before this court on that matter at sentencing. On top of that, the plea agreement provides that there shall be no pizza. Also, there is a language in there where the defendant agrees that he will agree to a order of prohibition from further participation under the FDIC Act, essentially abandon any licenses he has pursuant to that, and that is in subsection 2E of this particular plea agreement. Ultimately, this is also, when we get to sentencing, will be a negotiated sentence, Your Honor. And so the way that's going to work is under 2022 GS 47001, count 5, Mr. Lafitte is going to receive a term of 8 years imprisonment, which will run concurrent to the federal sentence that he will be sentenced on upcoming as well. He will also be sentenced to 5 years apiece on 2022-001 counts 4 and 6, which will be concurrent, not only to the state sentence, the lead sentence, but also those federal ones. In 2022 GS-002 counts 10 and 11, he's going to be sentenced to a term of 5 years imprisonment, again, that will run concurrent not only to the other state sentences, but to the federal time. And then in 2022 GS-47-003, count 1, he will be sentenced to a term of 5 years imprisonment consecutive. This one's going to be consecutive to the sentence in 2022 GS-47-00, count 5. He will also then, on counts 4, 5, and 6, on counts 2022, 3, counts 15 and 16, he'll get 5 years each concurrent. So we're going to have one lead sentence of 8 years from 2022 GS-47001. We're going to have a consecutive 5 years, which is 2022 GS-47003. And again, ultimately, both those sentences, the 8 plus the 5, will run concurrent to any federal time. On top of that, he will also get credit for time served under monitored house arrest, and the parties have agreed that that will begin on May 6, 2022. In addition to the consecutive 5 years on 2022-3 count 1, he will also have that consecutive sentence will be suspended, provided on the service of 5 years probation and 350 hours of community service. Your Honor, as part of this plea as well, he is waiving any appellate rights that he has, as well as his post-conviction relief rights that are waivable under the law. We would ask for a colloquy about that. And on top of that, obviously these counts are venued in Hampton and Allendale, and we would ask that there be a colloquy with the defendant on his voluntary waiver of venue to resolve the matters here in Richland County today. That's a summary of the most important provisions of the plea agreement, Your Honor.
All right, Madam Clerk, will you please swear Mr. Lafitte?
Mr. Lafitte, if you can stand and raise your hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
All right, counsel, do you explain the nature and elements of the charge, possible punishment, as well as Mr. Lafitte's constitutional rights?
We have, Your Honor.
And have you explained to him his right to have these cases heard in Allendale and Hampton counties?
We have, Your Honor.
So you agree to waive that?
He does, Your Honor.
And do you believe he understands the charges, potential punishment, as well as his rights?
I do, Your Honor. We've been over this and exhausted today.
Are you Mr. Lafitte?
I am
How old are you?
54.
How far did you go into school?
I'm a master's degree.
What do you do for a living?
I work on a family farm now.
You married?
I am.
Any children?
2 kids.
You suffer from any physical or mental condition that would prevent you from understanding what we're doing today?
I do not.
Have you consumed any alcohol, drugs, or other medication that would impair your ability to understand what we're doing today?
I have not.
You understand you have a right to have these cases heard in Allendale and Hampton counties, and you agree you're going to waive that to have me here today in Richland?
Yes, sir, I do.
All right, when you enter a guilty plea, you give up important constitutional rights. Those include the right to remain silent, not be compelled to testify against yourself. You also have a right to a jury trial, where the state would have to prove you guilty beyond a reasonable doubt. In the event you exercise your right to a trial, you have the right to have your lawyers cross-examine and confront witnesses against you and compel witnesses to appear and testify on your behalf. You also have a right to present certain defenses, which you waive or give up when you plead guilty. You understand all those rights?
I do.
Understand the rights I've explained to you if you wish to plead guilty and give up those rights?
I do, Your Honor.
All right. Now, you are pleading guilty to one count of criminal conspiracy carried for 5 years. Understand that?
Yes, sir.
You're also pleading to 2 counts of breach of trust with fraudulent intent value of $10,000 or more, both of which carry up to 10 years. You understand that?
Yes, sir.
There's another count of criminal conspiracy, again, which carries up to 5 years. You understand that?
Yes, sir.
Also, there are, it's like 2 more breaches of trust with fraudulent intent value of $10,000 or more, both of which carry up to 10. You understand that?
Yes, sir.
And there's charge of computer crime value of $10,000 or more, which carries up to 5 years. You understand that?
Yes, sir.
Finally, there's another criminal conspiracy which carries up to 5 years. You understand that?
Yes, sir.
You understand, but for the negotiations, you could have been sentenced up to 60 years in prison.
I do, Your Honor.
You understand here today, this is a negotiated sentence, which is a term of art, and that if I am to accept the plea, I'm to be bound by that sentence.
Yes, sir.
And you fully understand the nature of the charges against you and the range of possible punishment.
I do, Your Honor.
Are you satisfied with the manner in which the lawyers have advised or represented you?
I am, Your Honor.
Have you had the opportunity to review all the evidence against you and discuss it with your lawyers?
I have, Your
Do
Honor.
you need any more time to speak with them?
No, sir.
Do you believe they've done everything for you that they could have or should have done?
I do, Your Honor.
You know, are you completely satisfied with their services?
I am.
Other than the negotiated sentence, has anybody promised you anything or threatened you in any way to get you to plead guilty?
No, Your Honor.
You understand, ordinarily you would have a 10 days from the date of sentencing to appeal your guilty plea and sentence, but I believe you all had some negotiations about waiving that in your plea agreement.
That's correct.
You understand, you also had a statutory right to challenge your plea through a post-conviction relief process, and I understand you agreed to waive that as well.
That's correct, Your Honor.
All right, understanding the nature of the charges and the consequences of a guilty plea, how do you plead here today?
I plead guilty.
To all 8 charges?
I do.
Very good. Mr. Waters, tell me about it.
Yes, yes, sir, Your Honor. Thank you. And I'm going to hand up to Your Honor, I think I can approach Your Honor, a sort of a spreadsheet that sort of sets out the various individual transactions that we're going to talk about here today. I want to start out, of course, by acknowledging obviously the work of SLED and the state grand jury and some of the staff that we have here on this particular case, some who are not here, because it was obviously a part of the whole Ellen Murdaugh saga, and it was a ton of work that was done by these folks, and I want to acknowledge all their efforts here. I also want to point out and acknowledge that we have been in communication with the various victims that we have as a result of this. We have, of course, Greg Harris, who represents the bank. We have, that's Palmetto State Bank. Jim May represents the law firm. We have Justin Bamberg, who represents Natasha Thomas, Miss Pinkney, and Hakeem Pinkney, and I'll talk about them in a second. We have Mark Tinsley, who represents the Badger family, Eric Bland, who represents the Plotter family. And of course, I've had a chance to not only talk with those attorneys, but also the victims themselves as we've kind of sorted out this entire mess. Of course, they were all advised about this and are on board with this result. But to really explain to Your Honor exactly what happened here, and it's going to be a little bit long, but I'm going to move very quickly. But it is a complex story. And if there was a sort of, if Alec Murdaugh was 1A sort of in the community at this time, Mr. Lafitte was 1B. And Mr. Lafitte's family had ownership interests and control of Palmetto State Bank, and Mr. Lafitte himself over the years had served in a very senior capacity, senior vice president through a lot of this, and eventually became CEO of Palmetto State Bank until all of this blew up. And as a that contained the settlement and managing their living expenses and all the rest of it. And they actually told me that that Russell was very involved. He did, in many instances, was like a father to them. And we would look at the documents and we would see Mr. Lafitte getting approval for such things as school clothes and a little money to go to the fair and a computer for school and things like that. That's an interesting contrast, because when we talk about the fact that he was also appointed as conservator or PR in the Pinckney, Thomas, and Badger cases, all of them would tell you that they had no contact or hardly any contact with him whatsoever. And obviously, when he's appointed as a conservator or he's appointed as a personal representative in the context of this litigation, he has, as Your Honor well knows, that fiduciary duty, that duty of trust to act in the best benefit of the people who he is charged with protecting and shepherding. Well, in the Plyler case, while at the same time he's asking the probate court for express approval on very mundane and fairly small expenditures, he starts to, because he's got control of the account, Mr. Lafitte starts to loan himself and loan Alec Murdaugh money out of the Plyler accounts. And from July 2011 through December 2013, Mr. Lafitte loaned himself $340,000 out of the account set up for those little girls then that he was charged with shepherding and protecting. And he loaned Alec Murdaugh during this time period $963,500, almost $1 million of the money that was meant for the benefit of these little girls. Interestingly, although some of the paperwork that they turned into the probate court had the word loans on it, and supposedly these loans were at 1.5% interest or 2.25% interest, they never at once told the probate judge, "Hey, Judge, by the way, I got control of all this money for these little girls, and I'm going to loan myself, a third of $1 million, and I'm going to loan the lawyer on the case $1 million out of their money." And the reason why this is important is because, as I told you before, Russell had loaned in various other ways Alec money in multiple different types of accounts, multiple different types of loans. And Russell Lafitte would take an active role in managing Alec's accounts. We would see emails where Russell Lafitte would tell Alec, "Hey, I moved money from this account and from that account and moved it over here," without even asking. He would do that. And on top of that, there are instances where Alec is starting to get tight on loans and getting close to default on loans, and Russell Lafitte needs a payment, and he would contact Alec, and we would see emails where Alec would say, "Hey, just borrow some money from Hannah Plyler. Just borrow some money from the Plyler account." Well, ultimately, the Plylers, Hannah Plyler is going to reach majority in 2015. And not only has Russell Lafitte borrowed money from the Plyler account without fully disclosing this to the probate court and needs to get that paid back, but Alec Murdaugh has borrowed close to $1 million, and that needs to get paid back before that conservatorship ends and all of this comes to light. While he's loaning himself this money and loaning Alec this money to keep Alec afloat, Russell Lafitte also, over the course of this conservatorship, takes about $91,000 in fees, I should point out. He takes $60,000 in fees from Akeem Pinckney. He takes $15,000 in fees from Antarsha Thomas. He takes $35,000 in fees from Arthur Badger. And for those latter three, he doesn't do anything for them but sign his name and facilitate, as we will see, Alec's misappropriation of that money, which kept loans from defaulting that Alec had been received. It's also interesting that at the same time that Mr. Lafitte was giving these unsecured loans of little girl money to Alec Murdaugh and to himself, Alec is in a situation where 2 loans on which he's guarantors are being charged off by the bank for not being paid. Ultimately, and this is where we get to where the rubber meets the road, is Alec Murdaugh has a big case, and it is the Pinckney case. And I've spent a lot of time with Miss Pinckney. She was in a car wreck, hardly injured. Her relative, Natasha Thomas, was injured. And Hakeem Pinckney was seriously injured, rendered paralyzed, and ultimately perished. And Alec was the lead counsel in representing this crew. And of course, he has Russell Lafitte appointed as the conservator for Natasha Thomas, who was underage. I think he was 14 years old. And also as the conservator for Hakeem Pinckney. And if you look at the sheet that I gave you, and we'll start out with Thomas, which are the second 2 entries, but on the disbursement sheet for Natasha Thomas, she's ultimately getting paid settlement proceeds of just over $83,000. And this is on December 20th, 2011. But on there, there's also an entry to pay $325,000 to Palmetto State Bank. And this was the first main way that Alec Murdaugh was able to steal money from his clients, and he depended on Russell Lafitte to do it. Because the second that he could get a check cut from the law firm trust account, made out the Palmetto State Bank, he could give it to Russell Lafitte, and then Russell Lafitte would engage in whatever needed to be done to convert that for Alec's benefit, often to pay back loans or to get loans current. I think it's interesting to point out that every one of these trust account checks that would have gone to Mr. Lafitte, who also was serving as the conservator or the personal representative, and therefore responsible for signing off on these disbursements, every one of these checks was on a law firm trust account check, which are a different color than the operations account checks. And the law firm did business with Palmetto State Bank as well. And not only that, but every single one of them had on the memo line words to the effect of settlement proceeds from Natasha Thomas. But yet, Mr. Lafitte would take that check and convert it for Alec. And what did he do with the first one? This $325,000 on December 20th of 2011. And remember that date because it's going to be important. What did he do? What did he do for the conservator fee that he got in this particular case? He promptly got a money order signed by Mr. Lafitte for that $325,000 that was used to pay off money Alec had borrowed from his father, Mr. Randolph. But it didn't stop there. Again, this was a 14-year-old girl at the time. Because there was a second check for $25,245.08. And this was in June of 2012. And ultimately, on the disbursement sheet, as your Honor is well aware, there is often an entry for a medical lien that has to be paid out of the settlement proceeds. And what is typically the case is that a good lawyer, or a person who's actually acting in the benefit of their client's interest as a conservator, is going to try to negotiate with the medical provider and get them to settle on some amount less than that, and then create a delta, a difference, that then they can give to their client as part of the services they're providing. But in this instance, that created an opportunity to steal. And there was a medical lien on there. Ultimately, it was settled for less, and when you add in this attorney fee amount that was on there, it comes out to that perfect amount of $25,000 and change that was ultimately stolen from Ms. Thomas. And that was ultimately converted to, in 3 transactions, to the benefit of Alec, and again, through the use of money orders, which Mr. Lafitte signed. Around the same time, December 20th, 2011, in the case of Hakeem Pinckney, for which Mr. Lafitte received a $60,000 conservative fee, even though Ms. Pinckney recalls little, if any, interaction with them. Mr. Lafitte, as conservator, and Ellick put together a bunch of paperwork and signed a disbursement sheet on 12/20/2011, the same day as this Natasha stuff is going on, Natasha stuff. And in there is a line item for $309,581.46. Again, payable to Palmetto State Bank. Again, this is going to be a trust account check on the law firm that says settlement proceeds for Hakeem Pinckney on it. And it's delivered to Mr. Lafitte, and ultimately he then engages in a number of transactions, including at least 3 money orders that he signs to pay back a loan that his father, Mr. Lafitte's father, had given to Ellick Murdaugh, a 6-figure loan, to pay back money owed to Mr. Randolph, who had loaned money to Ellick, but also to pay back in 2 separate transactions $141,000 of money that Mr. Lafitte had loaned Ellick out of the Plower Girls account. The stolen money from Hakeem was used to pay back that money. It was also used to pay back money that had been loaned out of another account, Malik Williams, who also Russell served as conservator and had loaned money to Ellick. These transactions ultimately took place on 12/21/2011. This is very interesting, Your Honor, because Hakeem had died on October 11th, 2011. He was already dead, and Mr. Lafitte and Ellick Murdaugh pushed through all of this paperwork to get this done when he was dead. And you know what they did the very next day? On December 22nd, they filed the final accounting and petition to discharge. They pushed through all of this paperwork, knowing full well that he was dead, and then filed the paperwork with probate court the next day. But this wasn't enough, because again, not only was there all this money owed to the Plowers for which Mr. Lafitte was responsible, but there were all these other loans, mortgages, lines of credit whatsoever that Palmetto State Bank had given, for which he was responsible as well as the loan officer, as the primary executive responsible for that. And so we have the Arthur Badger case. And Arthur Badger was driving. He was in there with his wife Donna and some of their children, and there was a terrible wreck. And Donna perished. She died. Ultimately, Ellick gets Mr. Lafitte appointed as the personal representative for Donna's estate. But when it comes time to do the paperwork, Ellick tells the defense counsel to put all of this money essentially to be paid to Arthur Badger. And what they do is they have in there a reference to pay Palmetto State Bank for $1.325 million, over $1.3 million, Your Honor, payable to Palmetto State Bank. And on top of that, they actually put the PR fee for Donna into Arthur Badger's disbursement sheet. But the same thing happens. They get a check cut on the trust account, different color, that says that the state, Donna Badger for that $1.3 million. And then, and this is probably the most telling thing, is that Ellick sends an email to Russell and says, hey, I need you to send me an email to ask our firm CFO to cut this check, to void out the $1.3 million check and to cut it into various segments. And the point of that is because Ellick needs a little walking around money for this, he needs a little something for that, but also they need to generate the illusion of regular payments on Hannah Plyler's account, this supposed loan. He tells Mr. Lafitte how he needs to get that check recut out for that purpose. And Mr. Lafitte almost immediately sends an email saying, hey, can you get Jeannie to recut the check, multiple checks as follows? And she does so. Well, what happens with that? Ultimately, $388,000 goes to pay back money Alec had borrowed from a law partner. $75,000 goes back to pay Mr. Randolph. And over $482,000 goes to pay on the plywood loans. Of that amount, they pay in February of 2013. There is a payment made. And again, this is a check. It says Arthur Badger in the memo line. It is a trust account check, and it is given to Mr. Lafitte, and it is deposited into the plywood account. From September 2013 through December of 2013, there were multiple 5- and 6-figure payments made from that money, funded ultimately by what was stolen from Arthur Badger on the Plyler account. And again, these checks will say on them estate of Donna Badger, but they go to Mr. Lafitte and they are deposited into the Plyler account, as well as other expenditures as well to pay off Alec's Bank of America card, to pay Palmetto State Bank $50,000 to get current on something as well, and ultimately to get these loans current so they don't default. As part of that, funded by this $1.3 million in change, Mr. Lafitte cuts multiple money orders. Again, he's the one signing these throughout all of these cases. There's at least 2 instances in which he sends a wire, and when you look at the wire paperwork, it was Mr. Lafitte that was sending the wire on behalf of Alec Murdaugh. There's money that went to Cousin Eddie in a money order that was signed by Mr. Lafitte. And there was some cash out too, just for some walking around money as well. Those are the facts and state indictments. And I want to point out, and this is the last thing that I'll get to, I want to point out how that differs from what was alleged in the subsequent federal indictment that came out a number of months later. Ultimately, the feds charged things that had more to do with Mr. Lafitte's conduct in his senior position at the bank. Because one of these things he did was get a large 6-figure line of credit in order to pay back some of these loans we're here to talk about. Another thing that he did is that after the murders happened, Mr. Lafitte honored Alec's checking account that by August 2021 had gone to negative $347,000. And ultimately then Mr. Lafitte put $750,000, gave it to Alec, put $400,000 in his account and gave him $350,000 to send to Chris Wilson to try to fix that mess. And then ultimately they backdated loan paperwork to try to justify it. And on top of that, the feds also indicted the fact that when all of this started to fall apart and come to light, and the things about Alec Murdaugh were coming to light, without any approval from the board, Mr. Lafitte took $680,000 of bank money and took it to the firm as half of the Arthur Badger money, trying to head that off. But today, we're here talking about the Plylers. We're talking about the Pinkeys. We're talking about the Badgers. We're talking about Miss Thomas. And how Alec had become too big to fail for Russell Lafitte. How Russell Lafitte had become hot to Alec because Alec was so hot to him. And how Russell Lafitte was personally benefiting from having access to all the money in these conservator accounts in the case of the Plylers that he was loaning to himself. That's a fact, John.
All right, Mr. Lafitte, I don't expect you to agree with everything Mr. Crook or Mr. Waters just said, but do you substantially agree with the facts set forth by the state?
I do, John.
I find there is a substantial factual basis for the plea decision to plead guilty of freely, voluntarily, and knowingly made. Mr. Lafitte understands he's given up important constitutional rights by pleading guilty, and he's had advice and counsel from competent attorneys with whom he says he's satisfied. All right, I guess I don't need to hear anything from y'all today since we're going to delay sentencing. I believe we set October 13th at 10 a.m.
That's correct, Your Honor.
And Mr. Lafitte will not be taken into custody today. All of his bond conditions will remain, and we will reconvene in October and hopefully finally resolve this matter.
Thank you, Judge.
Thank you, Your Honor.
All right, y'all. Have a good day.
Thank you.
Madam Clerk, I just put, I noted on the sentencing sheet that please accept the days I did sign.
Please. Okay.